Hi.
Hi. Shall I start?
Just 1 second.
Hi. Hi.
Hi everyone.
Hello. Yeah, Simi, you can start.
Hello everyone.
Okay. Good afternoon, everyone. Welcome to another yet powerful session of Winds of the Change presented by Group 1E, leader Sarika Shah and Manisha Jain, and 1G, leader Simi Bagaria and Pallavi Bajaj. As we all know, that change is only constant in universe. So there has been a humongous change in the role of a woman, not only on the work front, but also in the household. As discussed earlier by our esteemed speaker, CA Namita Lakhotia, she is compelled to bring a change in every woman's life by helping her know her rights, duties, and responsibilities as a woman of the house. The co-founder of Dil Se Will and partner at Lab and Associate. Please give a round of applause to her, and or else we can all give a thumbs up. As we all know that she has engrossed us throughout the last week in the WhatsApp activity, and today the Excel sheet provided by her was a total boom for all of us. I'm myself planning to take a printout and keep it at my place and fill it up and obviously keep it up. Before moving further in this session, may I welcome the First Lady of Cafe, who's bringing actually the winds of change in Kolkata. Please welcome our very own Kavita Agarwal, the Karta Dharta of Cafe. Please a round of applause for her.
Thank you.
And a
thank
thumbs
you,
up
Ji.
also.
Thumbs up. Okay.
Ari,
So,
where's my
Namita, we are looking forward to yet another interesting session and very, very useful. Interesting sessions can be many, but this one is quite important and useful. And today's session is something which I'm really, really looking forward to because I also need to take that action. Spoken a lot of time with you, but action is still awaited. So please continue. Yes.
Yes. So, Namita, before we start, I want to ask everyone to post your queries in the chat box and we'll take up as required.
Can we do it after the session at one go, like last time? It will be better.
Yeah, we can do that also. Yeah,
Right.
we'll do that only. We'll take it after the session.
Yeah. So, so everyone, no one breaks the flow. We go in a flow, and later we can answer all the questions.
Yeah.
Yeah.
Okay. Yeah. Okay. Thank you. Over to you, Namita. Please start.
Yeah. Hello, everybody. Thank you so much for being with me in the last session and also throughout the week. It is overwhelming to see the response. I'm really happy that there is some wind of change, at least in some lives. And I'm sure others who are yet to see the documents, who are yet to take the action, will do it today after listening to the Power Packed session today. Okay. So like last time, I had shown you a video. This time, I'm not showing a video before my session, but to make your brain start tingling, we will start with some questions. Okay. So, jab bhi main, I speak to young women, and of course, women are always young. Whenever I speak to young people about inheritance, सब यही बोलते हैं, अभी क्यों? मेरे लिए too early. ठीक है? And for women, they are always young. So I will just put some questions and you keep the answers in your mind. And then we go through the entire session. And during the question answer session, we will take up any questions that you have. This is the flow of today, for today. Okay. I'll just share my screen. Everyone is able to see my screen?
Yes.
Yes.
Okay. Are you prepared for the inevitable? Have we started planning for our inevitable? Yes. And so how do we plan our succession and why do we need one? I will quickly rush through the questions, but this should be able to, tingle your brains. Are you a married woman having dependent parent? How will they manage after you? Are you a single parent? Do you have minor children? Are you a business owner? Do you have a successor to your business? Are you a married daughter? Do you know about your rights in your parents' property even after marriage? Is nomination enough for succession? Sorry. Young parents with dependent children? HUF, should we continue or partition? What could go wrong? Are you a philanthropist? Donate even after you are gone. Want to disinherit a legal heir from your property? How can you do it? Aging, no estate plan yet? Are you a pet parent, worried about the future of your pets? No legal heirs to bequeath your properties to? Children from 2 marriages? Who will inherit? Gen Z, not ready to carry your business further? Are your parents financially protected after your marriage? Gifting your property? Think again. Children out of wedlock know their rights. Testamentary trust, a great instrument for succession planning. Registration of a will, mandatory or recommendatory. Want to make a will for the benefit of a friend? Yes, you can. Divorced, you can change your will. Ancestral property, inheritance issues. Children with disability, act fast. Adopted child, but not legally. Spouse having children from previous marriage. Private trust, solution to many succession challenges. Want to make an online will? You want to make an offline will? You want to make a testamentary trust? You want to make a private trust? Want to get business succession planned and executed? Succession planning, no more a choice. See, all the questions that we went through, there a few things that should come to our mind are, we are falling in one or the other category of questions that I have put forward here, right? So for us, succession planning should no more be a choice. We should immediately jump into the act of collecting our data in one place and having a succession plan in place. So what I always quote, the greatest certainty in life is death. But the spelling of greatest here is wrong. I'm so sorry. The greatest uncertainty here is its time. Okay, so now we get into our session. Yes. So what will we learn? What will we learn today? We'll know about our inheritance, which also includes our rights and our duties. Okay, and we will learn how we can protect our wealth. We will also learn how to plan our succession. 1 hour is a very short time to learn everything, but I will definitely try to make it into a capsule so that you all can have it easily, right? Let's go. What are the inheritance rights of women in India? Okay, so first I'm talking only about the rights of Hindu female. Okay, now here I have taken up only Hindu female or Hindus because most of us belong to that religion due to the shortage of time. So please don't take it as, me being a religion bias, not like that, because it's 1 hour, we can only take up one religion. It cannot be all of them. But yes, I am here for all your succession queries for any religion that you want. But today we will talk about Hindu religion because we have lack of time, right? Okay. So what are the rights of a Hindu female? Right now, I'm not talking of inheritance rights. I'm talking only rights of a Hindu female. Okay. We should know what are our rights. So as a spouse, what is your right? So this is something new, prenuptial agreement. Okay. Not many of us have ever done it. And it is not a common thing for us Hindus to follow it. In countries abroad, it is a very common agreement which couples have before marriage. So they get into an agreement wherein they have their terms and conditions clearly stated. As much as who will change the nappy of the child after one has the child. So even to that detail, you can, write down. Excuse me. Okay. So in a prenuptial agreement, basically, what should be put up? I'm so sorry for my throat. Okay, so what in a prenuptial agreement? In a prenuptial agreement, usually it is stated that the wealth which is there with the individual before the marriage takes place, what happens to that? After the marriage, whoever is earning whatever, they can decide on it and make an agreement. But some people would be working for say 5, 7, 10 years before their marriage also. So that also needs to be stated clearly that, okay, this is my wealth, but this is for my parents and not for my spouse. Okay, so there is a prenuptial agreement. There is an agreement as to how our marriage should run. Okay. Stridhan. What is Stridhan? Stridhan is something which we get in a marriage. So it could be from our mother's side, it could be from our in-laws side. Okay. आप दोनों ही तरफ से आपको जो भी मिलता है वो आपका स्त्रीधन है and you have the full right on it. तो अगर किसी के फैमिली वाले बोलते हैं कि ये मैरिज गिफ्ट में जो आपको ज्वेलरी आई है ये आपकी नहीं है, ये फैमिली की है, ये गलत है, ये अगर आपको मिली है तो वो आप ही की है, दैट इज योर स्त्रीदान एंड यू हैव द राइट ओवर इट. Though you have not bought it, your husband has not bought it, or your father has not bought it, but you have the right over it because it has been gifted to you in your marriage. Okay. Spousal trust. Okay, spousal trust again is not very common in India, but a very fine instrument. इसमें क्या होता है, हम लोग एक ट्रस्ट बनाते हैं जिसमें हम लोग अपने स्पाउस के बेनिफिट के लिए ट्रस्ट होता है. तो दोनों स्पाउसेस ये बनाते हैं साथ में एंड इस ट्रस्ट में क्या होता है कि it is clearly mentioned that whatever property I have for the benefit of my spouse, this is the monthly money which the person will get so that the person can easily sustain and not have any lifestyle issues even if I'm not there. Okay, so the trust is made. And why instead of will, the spousal trust is made? Because spousal trust cannot be challenged, but will can be challenged. ठीक है, अगर आपको स्पाउस के लिए सिर्फ करना है, अपने बच्चों को भी नहीं देना है कुछ भी, तो इट इज बेटर कि आप ट्रस्ट बनाएं. We will talk about it later. Okay, maintenance alimony in case of discord. I think we all know if there is a marital discord, it is all you have the right to claim maintenance and alimony from your spouse. Inheritance and succession rights in spouses and in-laws estate. By virtue of marriage, you have certain rights, right? Those rights are also extended to the estate of the spouse and the in-laws. Okay, as a daughter, equal co-partnership rights in HUF, which means if there is an HUF of the parent, right? By birth, girls are now co-partners. Co-partners means they have equal right in the HUF as that of the son. ठीक है, तो अगर आपके फादर की HUF है, प्लीज नो दैट आपकी शादी हुई है या नहीं हुई है, आप You are the co-partner and you have the right over the share of the HUF. You have the right to inherit from your mother, father, or grandparents. As a mother, आपका क्या right है? As a mother, आपका guardianship right है. अगर आपका और आपके husband का नहीं बनता है, then also the husband can never take that right away from you, especially if it's a daughter. If it's a daughter, it is seen by history that the court will always want that the daughter stays with the mother for security issues. That बच्ची हमेशा माँ के साथ रहे. But for sons also, mother has a natural guardianship right. तो अगर suppose God forbid अगर किसी husband की death हो जाती है, हम लोग ने ऐसा case देखा था कि the husband expired. Now the in-laws are saying that we will not give any right to the wife or our daughter-in-law. The kids were really small, and the daughter-in-law filed a suit. And the court declared that the natural guardian has the first right to the child unless and until the natural guardian is not fit to take care, has habits which will spoil the child or will be, can cause any harm to the child. Unless and until there is any harm which is anticipated from the mother, the mother is always the natural guardian of the child. Adoption and child custody. So child custody is the right of the mother that I just explained, and adoption. So as a mother, we are, as a lady perhaps, we are allowed, even if we are not married, to adopt a child. We need not be married to adopt a child in our lives. Even single girls, unmarried, divorced, can adopt children and become mothers. Inheritance from children in specific instances. The mother is a legal heir to the children's property, but there are certain riders attached to that, and we will discuss that in detail. Okay, now we speak about inheritance rights of Hindu women, females. Okay, as a mother from son, the mother is a class 1 heir. We will speak about what is class 1 heir in later. From a daughter, she's third in order. That means in inheritance, the mother will always get from the son, but not always from the daughter. She's third in order. As a wife, she is the class 1 heir. She has the right to her spouse's property. As a daughter, unmarried or married, she has the right on the father's property. As a sibling, from a brother, she is a class 2 heir, so she does not have the right to the brother's property if the brother's mother and wife and children are alive. And from a sister, it is fourth in order, so it's far off. Rights in HUF I've already discussed. I'm just going to brush through again. As a daughter, by birth or by adoption, she's a co-partner. Co-partner, as I said, is a right which a girl or a boy gets only out of birth. They have the right to demand partition of the HUF. As a mother is not a member of the son's HUF. Why is mother not the is not a member of the son's HUF? Because the mother is the member of the father's HUF, and mother is not, the wife is the, see, by marriage, the wife is a member, not a co-partner. Why? Because co-partner is always by birth. It can never be by marriage. It is only by birth. And she has no right to demand partition in the family. HUF property. Okay. All right, so we start our study on succession, which is the main topic for today. And we will start it with a case study. Please go through this case study very carefully as I read it. Today's topic is a bit technical in nature, so please pay full attention to this. Ankur is a 55-year-old person, a self-made reputed businessman in Kolkata, having interest in IT and IT-enabled services. He has a father who is now retired and dependent. Please note the people in his family. So he has a father, he has a wife, though well educated, but chose to be a homemaker. He has a sister who is a widow and is dependent on him. He has a daughter who married against her father's wish, and Ankur does not have cordial relation with her. See, I have put in so many characters in the same story. Why? So that I can explain you the entire thing in one go. Daughter 2 is married to a businessman, is a director in husband's entity, and company is under insolvency. What is insolvency? Insolvency is a state where you cannot repay your debts. Okay? And daughter 2 has given personal guarantee against the loan taken by company. So she has become the guarantor to the loans that the company has taken, where she is the director. And who is actually who is running the company? The husband. Okay. He has a son who has done his higher studies and settled abroad, running his own venture and not interested in returning back to India. So Ankur got infected from COVID, and on the 6th day, so ultimately, after a 10-day fight, he departed. Hospital bills running in lakhs, yet to be settled. Okay. Do I need to go? Do I need to show the slide again? Because you need to remember who were the people connected with him.
Yes, I think the first slide we need to see once again.
This one? Yes. So please note, he has a father who is retired. He has a wife who is educated but a homemaker. He has a sister who is a widow and is dependent on him. He has 2 daughters. One has married against his wish. The other has been a personal guarantor in the loan which the company of her husband has taken. Okay, and the company. Yes.
Sorry to interrupt, Namita. I couldn't understand daughter 2. She's married to a businessman and
Right.
directed in husband's business. Okay.
Right.
So companies under insolvency. Which companies under insolvency? The father's company.
No.
The husband's company.
Right. The husband's company is under insolvency, and daughter 2 has given personal guarantee against the loan taken by the husband's company.
So why here are you giving the account of the husband's company? Do we have any relation?
Yes, of course. इतना मतलब कॉम्प्लिकेटेड हिंदी मूवी बनाने का एक ही रीजन है कि सब कुछ समझा सके एक ही जगह पर. ठीक है. तो ये सब हम लोग डिस्कस करेंगे. अभी से 5-6 स्लाइड बाद डिस्कस करेंगे. बट क्यों मैं बोल रही हूँ, वापस मैं दिखा रही हूँ कि आप लोग ये नोट करके रखिए. मैं जैसे जैसे आगे बढ़ूंगी ना, आप लोग को क्लैरिटी आता जाएगा कि मैंने क्यों लिखा है ये सब. ठीक है. Son has done higher studies. Then we see that he has left. Okay. Right. What are the after effects? Family is shocked and shattered. How would the family manage their immediate needs? So my questions to you guys. Okay. How will the family manage their immediate needs? Question 1. Question 2, who will manage the business? Question 3, who will take care of the father and the sister? Who knows what assets and liabilities he had and how to access that? How would one protect from misappropriating wealth accumulated for the benefit of the family? How to protect second daughter's share from getting it attached by the court? How to protect the distribution of wealth to first daughter? आप लोग इसका एक पिक्चर खींच लीजिए so that आपको लिखना ना पड़े इतना. ये questions आपको याद रखने हैं क्योंकि we will come back to these questions. Okay? Done? Can we move? One of the coordinators has to guide me, please. Simi, can we move?
Yes, we can move.
We can? Okay.
Yes.
Okay. So according to Indian statistics, property disputes, this is the statistics of the cases which are pending in court. Okay. 66% of them are property dispute cases. Okay. 10% are family dispute and others are 24%. Property dispute cases are generally when the succession is not rightly done. and are challenged. That is the time when there are property disputes. Okay, so we start about what is a will. A will is a document considered as a legal declaration of the intention of the testator. Who is the testator? The person writing the will. About the distribution or disposal of his possessions, assets, properties, etc. after his death. So in a document, what you have to do is you have to write what you intend to give and in which form. और किसको कितना देना है आपको. So about the distribution of what? Of his possessions. तो इसमें सबसे important क्या है? आपको distribution बताना है. दूसरा क्या है? आपको अपने possessions के बारे में बात करना है. ऐसा नहीं है कि आपकी कोई आपके ancestral property है जो आपके नाम पे नहीं है, आप उसको नहीं लिख सकते अपने wealth में, अपने will में. ठीक है? What are the common characteristics? It's a legal declaration of testator's intention with regard to his property, manifests only after the death. आप will कभी भी बनाइए, उस will come into effect only after your death. Can be revoked or reviewed any number of times. There is no fixed format. It can be handwritten also. It can be on a plain paper. We can bequeath both tangible and intangible assets. Who are the parties to the will? Either the testator or the testatrix, that is the male or the female. Who is writing the will is called the testator or the testatrix. Beneficiary, who is a beneficiary to the will? जिसको इस will के through कुछ मिलता है वो beneficiary होता है. ठीक है? तो वो individual भी हो सकता है, non individual भी हो सकता है. आप किसी NGO को भी दे सकते हैं, relative भी हो सकता है, non relative भी हो सकता है. आप अपने friend को भी दे सकते हैं. When they are young people, ऐसे आप अपनी girlfriend को भी सब कुछ दे सकते हैं. It can be a minor, it can be a person with special needs. Okay. There is something called a non-beneficiary in a will. तो non-beneficiary कौन है? Non-beneficiary वो इंसान है जिसको आप will में लिख देते हैं कि हमें कुछ भी नहीं देना है. ठीक है? तो वो हो गया non-beneficiary. Suppose one of your children, you do not want to give anything, so you can write the child's name and say, I do not want to give anything to this child. Who is the executor? Who can be the executor? Executor can be a single person. It can be two or more people together. It can be a firm, a CA firm, anything. Who can be the executor? Who is the executor? आपकी will को पढ़कर जो उसमें लिखा है उसको execute करे या उस terms को properly act out करे. जैसा जैसा आपने लिखा है उसको properly execute करने वाले को executor कहते हैं. ठीक है? Obtain probate. So will in Mumbai, Chennai and Kolkata needs to be probated. It's compulsory. Probate क्या होता है कि will को कोर्ट में जमा दिया जाता है और उसके बाद सारे लीगल हेयर्स को बुलाते नहीं है, सारे लीगल हेयर्स को एक नोटिस दिया जाता है कि ये विल है हमारे पास, आपको इसका कोई ऑब्जेक्शन है तो आप ऑब्जेक्ट कर सकते हैं. अगर कोई ऑब्जेक्शन आता है तो उस पे केस होता है. अगर ऑब्जेक्शन नहीं आता है तो उस विल को पास करके उस विल के हिसाब से डिस्ट्रीब्यूशन हो जाती है प्रॉपर्टी की. We need witness and there should be at least 2 witnesses and independent. What does independent mean? Independent just means कि जो विटनेस है वो बेनिफिशियरी नहीं होना चाहिए. मतलब जो विटनेस है उसको कुछ मिलना नहीं चाहिए उस विल में, तभी वो विटनेस बन सकता है. क्योंकि अगर विल चैलेंज हो गई तो वो वॉइड हो जाएगी, नल एंड वॉइड हो जाएगी. मतलब उस विल का कोई अस्तित्व नहीं रहेगा. ठीक है? प्रोबेट जैसे मैंने आपको बताया, अ कॉपी ऑफ द विल इज सर्टिफाइड बाय कोर्ट सील, एस्टैब्लिश्ड authenticity or the finality of the will, and an application needs to be made to courts along with payment of a fee. Probate is compulsory in cases of will executed within areas under jurisdiction of Mumbai, Madras, Kolkata High Courts. हाई कोर्ट अभी तक मद्रास हाई कोर्ट है, इसलिए मुझे यहाँ मद्रास लिखना पड़ा, वो अभी तक चेन्नई हाई कोर्ट नहीं हुआ है. Will outside these area if they related to immovable property situated within the above 3 areas. ठीक है, तो प्रोबेट और सब जगह भी होता है, बट इन तीनों जगह पर बिल्कुल कंपल्सरी है प्रोबेट होना. सक्सेशन सर्टिफिकेट क्या होता है? फॉर इंटरस्टेट सक्सेशन. ओके, नाउ व्हाट इज इंटरस्टेट सक्सेशन? इंटरस्टेट सक्सेशन होता है जब आपने अपनी विल नहीं बनाई. ठीक है, तो उसमें क्या होता है कि हमारे लॉ के हिसाब से जो हमारे लीगल हेयर्स होते हैं उनके बीच में हमारी संपत्ति को डिवाइड कर दिया जाता है. द एंटायर प्रॉपर्टी इज डिवाइडेड टू द लीगल हेयर्स अकॉर्डिंग टू द लॉ, एंड इन इंडिया this law is determined by the religion you fall under. For Hindus, we have the Hindu succession law. For Muslims, they have Muslim law. The Parsis follow the Indian Succession Act. So the religion which you fall under will decide कि आपके ऊपर कौन सा सक्सेशन लॉ एप्लीकेबल होगा. इट्स नॉट कि सबको एक ही लॉ, सबके लिए एक ही लॉ रहता है. ठीक है, बट अगर आपने अपनी विल बनाई है तो इस लॉ के ऊपर होती है वो विल. मतलब अगर आपकी विल है तो आपने लॉ में जो भी बोल रहा है इट इज इमटेरियल, आपकी विल सस्टेन करती है. ठीक है, so when do we need a succession certificate? For interstate succession. इसका मतलब अगर विल नहीं बनाया तो सक्सेशन सर्टिफिकेट की जरूरत पड़ती है. हमें सक्सेशन सर्टिफिकेट कैसे मिलेगा? We will have to apply in the jurisdictional court. Details of all the legal heirs and properties have to be given, and properties are then distributed by applying the succession law and not as per the wish of the deceased. मतलब wish of the deceased कब हम लोग follow कर सकते हैं? Only if you have made a will.
Yes, very clear. We can move forward.
Okay. Now, who can make a will? A person who has attained majority, if you're 18 years of age and is of sound mind. ठीक है, तो illiterate है तो भी बना सकते हैं. If you're not educated, it is not that you cannot make. You are of the age of majority, you have a sound mind, you can make. Any old person can make. Terminally ill person can make. Intoxicated person, one who does not understand what is he doing, cannot make when he is intoxicated. तो जब intoxication की state में है उस समय वो will नहीं बना सकता है. So अगर कोई will ऐसे टाइम पे साइन की हुई है जब ये प्रूव हो जाए कि वो intoxicated था, तो that will is null. Okay, deaf, dumb, blind, all of them can, provided she knows what she is doing. So if there's a blind person, वो अगर verbally advocate को बता देता है उसको क्या लिखवाना है, and advocate writes it, and there's someone who can read it to that person और फिर sign करा लेते, तो it's a valid will. Okay, ordinarily insane. There is a psychological issue when a person gets insane in intervals. कभी कभी वो सेन रहता है और कभी कभी वो पागलों वाली हरकत करते हैं या इंसैनिटी वाली हरकत करते हैं. तो इन पीरियड्स ऑफ इंसैनिटी वो विल नहीं बना सकते हैं, बट इन पीरियड्स ऑफ सैनिटी वो बना सकते हैं विल अपनी. ओके, सो नाउ वी कम टू इंटरस्टेट सक्सेशन फर्स्ट. इंटरस्टेट सक्सेशन जब आपने विल नहीं बनाई, इन केस अ पर्सन डाइज विदाउट हैविंग विल इन इंडिया, ये केस ज्यादा होता है. In India, there is a very low rate of making will. It is termed as interstate succession, and the succession law shall be applicable. So for Hindu, Jains, and Sikhs, it's Hindu Succession Act. For Christians, Parsis, and Jews, it's Hindu Succession Act. For Christians, Parsis, and Jews, it's Indian Succession Act. And for the Muslims, it is the Muslim law. In Muslims, again, there are diversification in the law with their castes like Shias and the Sunnis. So it is a little complicated. Okay. So now we come to the legal heirs. This is very, very interesting. If there is a male Hindu dying without a will, what happens? ये जो 4 क्लास हमने लिखे हैं, class 1, class 2, class 3, class 4, इनको मिलता है, बट कैसे मिलता है? पहले क्लास 1 वाले लोगों को लिया जाता है। तो अगर क्लास 1 वाले लोग कोई भी है तो उनको ही मिलेगा, और कितना मिलेगा? इक्वल मिलेगा। अगर 2 लोग हैं तो 50-50 मिलेगा, 3 है तो 33, 33.33 ऐसे मिलेगा, एंड अगर 4 है तो 25-25% करके मिलेगा। तो इट इज नॉट दैट कि 8 जन को पूरा मिल जाएगा। क्लास 1 में जो है उनको इक्वल मिलेगा। क्लास 1 से अगर कोई नहीं है तो क्लास 2 को मिलेगा। क्लास 1 और 2 दोनों से कोई नहीं है तो फिर क्लास 3 में जाते हैं। So this is the order. Now let's see who all are there in class 1. Class 1 is first children. So son, daughter, mother and widow. ठीक है, पहले आप लोग ये 4 चीज याद रखिएगा, बिकॉज अगर किसी हिंदू मेल की डेथ हुई है तो फर्स्ट क्लास 1 हेयर में ये 4 सबसे इंपॉर्टेंट है। चिल्ड्रन में सन, डॉटर, द मदर and the widow. So look at this, that the father is not there in this.
Namita, one thing I would like to ask, is there any order in this also कि पहले बेटे को मिलता है फिर
और
बेटी को?
हिंदू मेल इसमें ऑर्डर नहीं है, और हिंदू मेल इसमें ऑर्डर नहीं है। जितने लोग रहेंगे इस क्लास 1 एयर में, ठीक है। तो नाउ लेट मी एक्सप्लेन दिस अ लिटिल मोर, बट जैसे उसके बाद क्या है? चाइल्ड ऑफ प्री डिसीज्ड चाइल्ड, व्हाट डज दैट मीन? अगर किसी का कोई भी चाइल्ड पहले मर जाता है, जैसे अगर जो जिसकी डेथ हुई है उसका सन अगर प्री डिसीज्ड है, डाइड बिफोर द फादर, तो उसकी विडो को मिलेगा, उसके बच्चे को मिलेगा। तो दैट्स व्हाई आई हैव रिटन हियर विडोड डॉटर इन लॉ, DIL इज डॉटर इन लॉ। ओके, तो बेसिकली आपको ये समझना है कि सन को मिलेगा, डॉटर को मिलेगा, मदर को मिलेगा और विडो को मिलेगा। इन अब जैसे सन या डॉटर नहीं है तो उनके सक्सेसर्स को मिलेगा। तो उनके सक्सेसर्स कौन हुए? द विडो, द चिल्ड्रन, इस तरह से इट विल गो ऑन। तो प्राइमरी अगर आप ये 4 चीज याद रखते हैं ना तो बाद का भी आपको याद हो जाएगा, ठीक है। क्लास हुए कौन हुए? फादर, सन्स, डॉटर्स, चिल्ड्रन। तो सन अगर प्री डिसीज सन है तो उसकी डॉटर को तो क्लास 1 में मिल ही रहा है, बट अगर क्लास 1 में से कोई नहीं है तो किसको मिल सकता है? फादर को मिल सकता है, सन्स, डॉटर्स, चिल्ड्रन को मिल सकता है, और सिबलिंग्स को मिल सकता है, तो ब्रदर, सिस्टर, इनको मिल सकता है। नाउ लुक एट दिस, इट्स वेरी सैड दैट पोते को पहले मिल जाएगा या पोती को पहले मिल जाएगा, बट फादर को नहीं मिल। तो अगर किसी की मदर पहले एक्सपायर कर जाए, उसको विल जरूर बनानी चाहिए उस मेल को, बिकॉज द फादर को उसकी प्रॉपर्टी में कभी कुछ नहीं मिलेगा if that person predeceases, if the widow is there, if the children are there. You should be very careful that father को include किया जाए will में। Okay, class 3 heirs are the agnates. Usually class 1, class 2 से मिल ही जाते हैं लोग हमारी हिंदू, एटलीस्ट हिंदू फैमिलीज में। they are the people from the father's side. अगर कोई भी आपकी फैमिली में नहीं है, फादर के ब्रदर के बच्चे हैं, तो उनको मिल जाएगा, ठीक है। क्लास 4 एयर्स होते कॉग्नेट्स, मतलब मदर की साइड से, तो मामा की साइड से जो फैमिली है उनको मिलेगा। तो क्लास 3, क्लास 4 इज इन रेयरेस्ट ऑफ सिनेरियोस की जरूरत पड़ती है। क्लास 1, क्लास 2 में एग्जॉस्ट हो जाता है जनरली। ओके, नाउ लेट्स हैव सम फन. We will just ask ourselves some questions. Okay, we have this male who is expired, and the heirs left are mother, father, wife, son, daughter-in-law, daughter, and son-in-law. So who will get it? You have to write down your answer on your paper or in your mind, and I will flash the answer now. The mother, wife, son, daughter shall get 25% being class 1 heirs. Each of them will get 25%. Father, even though alive, won't get any share as he is a class 2 heir. And daughter-in-law would get share only if the son has already expired. तो यहाँ पे ये नहीं लिखा है कि ये जो daughter-in-law है ये वो इसी son की wife है. So it is still an ambiguity. अगर ये pre-deceased son की wife है तो उसको मिलेगा, नहीं तो नहीं मिलेगा. Who is a class 2 heir? Who is a class 2 heir? Father. तो अगर हम लोग ने यहाँ क्या लिखा है? फादर इवन दो अलाइव वोंट गेट एनी शेयर एज क्लास 2 हेयर, ठीक है। Okay. Case 2. Who are the heirs left? Wife, brother, sister, son's widow, predeceased daughter's son. So who will get? Wife will get, son's widow will get. So if it's a predeceased child, उनके हेयर को मिलता है, तो son's widow will get. Predeceased daughter भी है, तो predeceased daughter's son को भी मिलेगा, ठीक है? And they would get 33.33% each. Siblings, that is brothers and sisters, being class 2 heirs, won't get anything as class 1 heirs are already present. Class 2 heirs को कब मिलता है? जब class 1 heirs नहीं रहते हैं, ठीक है? Okay. Now female Hindus who dies without a will. इसमें class 1 heir, class 2 heir नहीं होता है. We have a succession order. Succession order क्या होता है? कि फर्स्ट ऑर्डर को पहले मिलता है, उसके बाद सेकेंड ऑर्डर को मिलता है, फिर थर्ड ऑर्डर को मिलता है, ठीक है? फर्स्ट ऑर्डर क्या है? सन, डॉटर एंड हस्बैंड. इट्स वेरी सैड दैट आवर पेरेंट्स आर नोवेयर. एटलीस्ट सन के लिए मदर तो लिखा हुआ था, फॉर डॉटर्स मदर भी नहीं है, ठीक है? इफ द हस्बैंड इज देयर एंड द चिल्ड्रन आर देयर, आवर पेरेंट्स डू नॉट गेट एनीथिंग इफ वी डू नॉट राइट अ विल फॉर देम. ओके, अगर सन नहीं है, डॉटर नहीं है, हस्बैंड भी नहीं है, देन हु विल गेट? हेयर्स ऑफ द हस्बैंड, ठीक है? अब हेयर्स ऑफ द हस्बैंड में ऐसा है ना कि कौन कौन होते हैं? हेयर्स ऑफ हस्बैंड होते हैं मदर, विडो. तो विडो तो नहीं है, मदर, द विडो जस्ट एक्सपायर्ड एंड द मदर वी प्रिज्यूम इज नॉट देयर and children are not there. तो heirs of husband में class 1 नहीं है अगर, तो या तो उसके फादर इन लॉ को मिलेगा या हस्बैंड के ब्रदर सिस्टर्स को मिलेगा, class 2 heirs को. Heirs of husband, this is little technical in nature. People might have a little issue in coming to this ladder कि कैसे derive हुआ है. And third in order are parents. तो our parents come third in order. अगर हस्बैंड के भी कोई हेयर्स नहीं रहे तो फिर पेरेंट्स को मिलेगा, राइट? एंड उस वाई पेरेंट्स के बाद फिर हेयर्स ऑफ फादर. अगर पेरेंट्स भी नहीं है तो फिर हेयर्स ऑफ फादर को मिलेगा, और अगर हेयर्स ऑफ फादर भी नहीं है तो फिर हेयर्स ऑफ मदर को मिलेगा. बट देयर इज एन एक्सेप्शन टू दिस. इफ द प्रॉपर्टी इज इनहेरिटेड फ्रॉम पेरेंट्स, मतलब अगर फादर ने अपनी डॉटर को कोई प्रॉपर्टी दी है and the daughter expires and the daughter does not have any children, then the property can go back to the father, and if the father is not there, to the father's heirs. Okay, if the property is inherited from husband or father-in-law and lady dies without any children, then property reverts to husband's heirs. Okay.
Namita, I would like to ask one thing. If the female dies, what about the Stridhan? Who gets the Stridhan of the female?
So if there is no will, without a will, agar she dies, in that case, it is through the succession law. Succession law will, कुछ भी है उसका, कुछ भी समान है, वो succession law के तहत ही उसको disburse किया जाएगा, ठीक है? तो एब्सोल्यूट प्रॉपर्टी जो होती है वो क्या होती है और इनहेरिटेड प्रॉपर्टी क्या होती है, ये जानना बहुत जरूरी है. इनहेरिटेड प्रॉपर्टी तो वी ऑल नो इट इज ईदर इनहेरिटेड फ्रॉम द पेरेंट्स और फ्रॉम द हस्बैंड और फ्रॉम इन-लॉज और फ्रॉम एनी अननोन पर्सन, इट कुड बी, ठीक है? एंड एब्सोल्यूट प्रॉपर्टी क्या होता है? जो उसको इनहेरिटेंस में मिला है एंड इज ऑलरेडी इन हर नेम, एंड अगर वो फादर का है इनहेरिटेड तब तो वी हैव एक्सेप्शंस. अगर वो किसी और से मिला है, सपोज यू हैव एन अंकल, कोई कजन अंकल है जिन्होंने एक अच्छी प्रॉपर्टी आपके नाम करके विल करके गए थे, वो आपके नाम पे हो गई, तो वो आपकी एब्सोल्यूट प्रॉपर्टी हो गई है, ठीक है? पार्टीशन के टाइम में अगर आपको कुछ मिला है, पार्टीशन इज व्हाट? एचयूएफ के पार्टीशन में, अगर एचयूएफ के पार्टीशन में आपको कुछ मिला है तो दैट इज योर एब्सोल्यूट प्रॉपर्टी. In lieu of maintenance, मतलब अगर if you do not have a cordial relationship with your spouse and you have stepped into a divorce, then in lieu of maintenance अगर आपको कुछ मिलता है तो that is your absolute property. Gift कुछ मिलता है तो it's your absolute property. And if you have used your own skill to purchase anything, that is also your absolute property. Okay. All right. Again, we'll have some questions. A Hindu female dies intestate, leaving behind her son, her husband, one son and one daughter, and no parents. So who gets it? ये क्वेश्चंस मैंने छोटे छोटे क्यों बनाए हैं, क्योंकि देखिए वो जो चार्ट बनती है ना बड़ी कंफ्यूजिंग हो जाती है कभी कभी. ये क्वेश्चन से थोड़ा ब्रश अप हो जाता है एंड इट बिकम्स क्लियर हु गेट्स इट. सेल्फ अर्न्ड अगर है तो किसको मिलेगा? हस्बैंड सन डॉटर शैल गेट 1/3 ईच. ठीक है. इनहेरिटेड फ्रॉम पेरेंट्स है तो किसको मिलेगा? सेम, हस्बैंड सन डॉटर. वाई? बिकॉज फादर को तो तभी मिलेगा अगर चिल्ड्रन नहीं हो. हस्बैंड हो तो भी मिलेगा, लेकिन अगर चिल्ड्रन नहीं हो तो. इनहेरिटेड फ्रॉम इन-लॉज होगा तो भी सन डॉटर को मिलेगा एंड हस्बैंड को 1/3 मिलेगा. ठीक है. Hindu female dies intestate, no husband and children, parents and in-laws are living. ठीक है. Parents are also living, in-laws are also living. So now self-earned है तो who will get? Husband's legal heirs, because second in order tha husband's legal heirs. Do you remember? See, we'll see here. Second in line tha husband's legal heirs, right? So the husband's heirs will get it. Okay, inherited from parents to legal heirs of father. Inherited from in-laws to legal heirs of husband. Hindu female dies intestate, has no husband, no kids, no in-laws. One brother-in-law is living and parents are alive. Okay, self-earned property है तो किसको मिलेगी? Husband's legal heirs. Inherited है अगर ये सब तो किसको मिलेगा? Father's legal heirs को मिलेगा. And inherited from in-laws है तो किसको मिलेगा? Husband's legal heirs को मिलेगा. In this case, inherited from parents है तो वो किसको चला जाएगा? Parents को चला जाएगा. Inherited from in-laws अगर है तो वो किसको चला जाएगा? Brother-in-law को चला जाएगा. Because in this example, brother-in-law is the only person living from the husband's legal heirs chart. Okay. Hindu female dies intestate, separated from husband but not divorced. Please remember, separated होने से भी if legally not divorced, succession law will treat you as married. One son and one daughter alive. She never wanted to give anything to the husband. Self-earned है तो क्या होगा? Husband को भी मिलेगा and son and daughter को भी मिलेगा. So she can do nothing about this कि वो husband को ना मिले. If she is not writing a will. Inherited from parents. So same. अगर बच्चे हैं तो husband, son, daughter तीनों को मिलता है. Inherited from in-laws होगा तो same. Husband, son and daughter तीनों को मिलेगा. Okay, let's have some mythbusters. Will needs to be registered or on a stamp paper. It's absolutely wrong. There is no statutory requirement to register a will. आपको register करना जरूरी नहीं है will. ठीक है. हम लोग recommend करते हैं कि आप will register कीजिए. क्यों recommend करते हैं? क्योंकि उसकी एक कॉपी फिर रजिस्ट्रार के पास रहती है तो प्रूव करना इजी होता है कि जो विल प्रोड्यूस हुई है कोर्ट में वो असली विल है, क्योंकि एक कॉपी हम लोग रजिस्ट्रार से रिट्रीव करा सकते हैं. राइट. इसीलिए रजिस्टर करना अच्छा होता है. पर अगर किसी का फैमिली बहुत सॉर्टेड और पता है विल चैलेंज नहीं होगा, then in that case registration is not compulsory. Will needs to be written on a stamp paper? No. One can write on plain paper also. ठीक है. I have appointed nominee. Do I need a will? A very, very common question. Please understand, will prevails over nomination. Please remember, will prevails over nomination, which means that nomination आप कुछ भी कर लें, लेकिन अगर will में आपका कुछ और लिखा हुआ है तो will ही prevail करेगा. नॉमिनेशन में आप कुछ भी कर लें, पर अगर सक्सेशन लॉ के हिसाब से वो आपके लीगल हेयर्स नहीं है तो भी कुछ नहीं कर सकते हैं, लीगल हेयर्स को ही मिले. So if you have a will, the will supersedes. If you have no will, the succession law will prevail. So nominees are only the caretaker. Okay? Nominees may or may not be the legal heirs. जब हम लोग नॉमिनी बनाते हैं तो कई बार हम लोग अपने लीगल हेयर्स को नॉमिनी नहीं बनाते फॉर व्हाटएवर XYZ रीजन. अगर हम लोग ऐसा कर रहे हैं और सच में चाहते हैं कि जो भी हम जिस भी चीज में हम नॉमिनी बना रहे हैं वो एक्चुअली उस नॉमिनेटेड पर्सन को जाए, तो हमको विल में भी वही लिखना. देन ओनली दैट पर्सन. ओके. In case a person dies without will, the nominee has to pass on the asset to the legal heirs as determined by law. Okay. I have joint holders. Do I need a will? Yes, you need a will even if you have a joint holder. Either or survivors. कौन होता है? Can transact along with the first holder. Former or survivor क्या होता है? Can transact only after the first holder dies. Joint holder is not the beneficial owner. ऐसा नहीं है कि jointly held जो होता है वो सब कुछ जो joint holder है उसके पास चला जाता है. ऐसा नहीं है. अगर किसी जॉइंट होल्डर की डेथ होती है तो लीगल हेयर्स को ही जाएगा. ठीक है. ओनरशिप रिमेन्स विद बेनिफिशियरीज अंडर विल और लीगल हेयर्स अंडर द एक्ट. It's too early to make a will. The most common thing we hear around us. And I think after COVID, this world has seen enough. I think we should stop saying this. And why only COVID? Even after COVID, haven't we seen a rise in deaths, immature deaths, and early deaths around us? I mean, and we keep hearing about them. We keep reading about them in the newspaper. So is it really too early to make a will? So, it's just a fun way of telling you that it's not, because expiry date is not mentioned. आपकी expiry date आपको पता थोड़ी ना है. जैसे हम लोग दवाई की शीशी पे लिखा रहता है expiry date, कुछ खाने के सामान पे लिखा रहता है, हम पर expiry date लिखा नहीं होता ना. No one knows about it. Individual family concept and society getting westernized. What does this mean? पहले के जमाने में क्या होता था कि joint families थी. Joint families होती थी तो अगर कोई अनटाइमली कुछ हो भी गया तो बाकी पूरी फैमिली खड़ी हो जाती थी. पूरी फैमिली टेक केयर करती थी उस परिवार का और उस सदस्य का या उस लेडी का या उस स्पाउस का जिसके ऊपर ये संकट आया है या जिसके साथ ऐसा हुआ है. राइट. बट इन टुडेज टाइम, डू वी रियली हैव द टाइम टू गो आउट एंड हेल्प सच पीपल? एक बार, दो बार, तीन बार चले जाएंगे, बट हम लोग क्या रोज ये काम कर पाएंगे? हमारे पास इतनी टाइम है? इंडिविजुअल फैमिली कॉन्सेप्ट जैसे जैसे बढ़ रहा है, इट इज वेरी इंपॉर्टेंट दैट हम लोग अपनी फाइनेंशियल्स अपने हाथ में लें एंड हमारे डॉक्यूमेंट सही हो एंड वी मेक आवर विल. इट्स वेरी वेरी इंपॉर्टेंट. राइज इन यंग डेथ्स इन इंडिया. As soon as one starts earning and having dependents, he or she should consider making a will. जैसे ही अर्निंग स्टार्ट हो जाए या हमारे ऊपर कोई डिपेंडेंट हो जिसके करता धरता हम लोग हों, और हम लोग को अपनी विल बनाने का सोच लेना चाहिए या एटलीस्ट उस तरफ कदम बढ़ाना शुरू कर देना चाहिए. What if I change my mind? You can revisit your will in case you have changed your mind any number of times. For minor changes, you can make codicil, and for major changes, you can make a new will. What is a codicil? A codicil is an attachment to your original will, stating कि हम लोग का ये क्लॉज चेंज होके ये रिप्लेस हो जाएगा. क्योंकि छोटा सा चेंज है ना, तो हम लोग एक पेपर चेंज करके ही कर सकते हैं. मेजर चेंज होगा तो हम लोग को नई विल बनानी पड़ेगी. ठीक है. The latest will is valid and supersedes all existing wills. कौन सी will valid होती है? जो सबसे लास्ट डेट पे बनाई गई होती है. तो अगर किसी के मरने पे 6 विल मिली है तो कौन सी विल वैलिड होगी? लास्ट डेट वाली विल वैलिड होगी. ठीक है. It is advisable to revisit your will at least 3 years at least once in 3 years. Why do we say so? Because a lot changes in 3 years. We may have a relationship status change. We may have a new addition in the family. We may also have someone who has left us. Also, there may be a change in our mind about the beneficiary. कि हाँ इसको ये मिलना चाहिए या एक जन को हाउस प्रॉपर्टी एक को ऑफिस मिलनी चाहिए. Suddenly we think कि नहीं उसको ऑफिस की जरूरत नहीं है. That person doesn't need the office because that person already has a lavish office and this office may not be of use to that person. So we want to give it to someone else. So every 3 years you should revise your will. At least go through your will, see if you want to make any changes and do the needful. Why will? I can gift. See, when you gift, what happens is you immediately relinquish your right in the property. Okay, there is stamp duty you have to pay when you gift your when one has to pay when you gift. Gifts are generally irrevocable. आप एक बार अपनी प्रॉपर्टी एक गिफ्ट डीड में किसी को दे दिए, आप उसको रिवोक नहीं कर सकते हैं. पर आपने अपनी विल में अगर लिख दिया है, साल भर बाद आपको लगता है ये इंसान मेरा ख्याल नहीं रख रहा है या ये इंसान does not deserve it, you can change your will, right? That is why don't gift. I do not personally advise anyone to gift beforehand. I would always say that wait, make your will, keep it. आपको जो भी देना है आपके जाने के बाद दीजिए. There are tax implication in gifting if you are gifting to a non-relative. ठीक है, अगर आप blood relative को छोड़ के अगर आप gift करें तो there are tax implications and we will not get into the tax implications right now. Okay, there's a very famous case. We will just touch upon this. Singhania versus Singhania. We all know Raymond's as a brand, right? Uske owner, founder, Mr. Vijaypad Singhania. What he did was he was holding 37% of Raymond's Limited shares, which was worth rupees 1,000 crores. That was back in 2015. Okay, and he gifted this entire thing to his son, Mr. Gautam Singhania, under the thought कि हाँ ठीक है, अब सब कुछ उसी को देखना है, ठीक है? But it was very famous, and if any one of you has read in the papers, he explicitly mentioned that in the 79 years of my life, I never thought that I would have to take a family dispute to court after giving away everything I had, and that I wouldn't even have a roof over my head. A multi-millionaire did not have anything because उन्होंने पहले से सब कुछ gift कर दिया. HUF assets क्या होते हैं? वो assets जो हम लोग HUF के अंडर होते हैं, personal नहीं होते हैं, वो HUF के assets होते हैं. One can bequeath her share in HUF through a will. Whole HUF property cannot be bequeathed. मतलब अगर आपको अपनी विल में अपनी HUF की शेयर के बारे में कुछ लिखना है, you can just write that my share in the HUF named so this is bequeathed to so and so person. आप ये नहीं लिख सकते कि हाँ ठीक है उसमें जो हाउस प्रॉपर्टी वो हम किसी को दे रहे हैं, बिकॉज HUF में बहुत जन का शेयर होता है, तो आप सिर्फ अपना शेयर किसी को दे सकते हैं. It can be given to any relative or non-relative. ऐसा नहीं है कि वो HUF का मेंबर होना चाहिए. आप विल में अगर लिख रहे हैं तो आप रिलेटिव को भी दे सकते हैं, नॉन रिलेटिव को भी दे सकते हैं. On death, his share is freezed and is distributed as and when the partition takes place. Distribution of his share does not take place before partition of the HUF. जब तक HUF partition नहीं होगा तब तक शेयर जिसको भी देना था उसको नहीं दिया जाएगा. Okay, trust is another way of succession. It helps avoid estate duty, though we do not have estate duty in India, but in most of the countries there is estate duty. It reduces succession disputes. Why succession disputes are reduced through trust? Because iska control, first of all, the trust cannot be challenged. Trust को आप challenge नहीं कर सकते. जैसे विल को आप फिर भी चैलेंज कर सकते हैं, ट्रस्ट को आप चैलेंज नहीं कर सकते हैं. तो अगर इफ यू हैव अ डिपेंडेंट हु कैन नॉट टेक केयर ऑफ हिमसेल्फ और हरसेल्फ, ट्रस्ट इज इनएविटेबल, क्योंकि तब सारा कंट्रोल ट्रस्टी या ऐसे इंसान के हाथ में होता है जिसपे आपने फेथ करके ये सोचा है कि वो इस ट्रस्ट के थ्रू जो भी डिपेंडेंट है उसका पूरा टेक केयर होगा, राइट? So this trust need not only be formed for the dependent, it can be for various purposes, but I'm just giving an example that when can trust be used. No need of obtaining probate. अगर will में आप लिखते हैं तो of course probate लेना पड़ता है, but अगर आप trust बनाते हैं तो आपको probate नहीं लेना पड़ता है. Complete control during lifetime and after death also, क्योंकि trust में हम लोग clauses लिख देते कि these are the clauses through which my trust will be running. So there is obviously a control that how the money is being used, how selling can be done, how things can be changed, how the property can be, maybe partially sold, whatever. Useful if beneficiary is minor, physically or mentally challenged. So I will share a very short story with you here. It's not a story. It is it is a real life story. I have an acquaintance in Mumbai. She's a single mother. 2 years back, she thought she had a lump in her breast, and before even getting it tested, she had called me and she said कि नमिता मुझे immediately उसका सन उस समय 10 साल का था और उसने मुझे फोन करके यही बोला, नमिता मुझे कुछ हो जाएगा अब 3-4 महीने में, तो यू हैव टू डू समथिंग. तो मैंने उसको पूछने पे उसने बताया नहीं अभी टेस्टिंग नहीं हुआ है, बट टेस्टिंग होने के तुरंत बाद मुझे इलाज कराना पड़ेगा और कोई है नहीं तो मैं ये कैसे करूं. तो मैंने बोला ठीक है, तो आप ट्रस्ट बना लो. ट्रस्ट बनाकर you can give everything in the trust and then make trustees so that all this can be taken care of by God's grace. She was detected with cancer, but it was cured. She's fine now, but she had made a trust immediately before getting into the cycle of any kind of medicines or chemos. She had made her trust. So she was a single mother, and for her that situation was a very worrisome situation. So this is when the trust becomes very, very useful. Okay, will versus trust. I've already discussed this. When does it take effect? Will comes to effect on death. Trust can come into effect immediately or on death, depends. आपको ट्रस्ट कब, अगर आप टेस्टामेंट्री ट्रस्ट बनाती हैं तो वो डेथ के बाद it comes into effect. If you make a normal trust, it comes into effect immediately. Probate, dispute, litigation can happen in will. In trust, no. Control after death, will पर कंट्रोल ये है कि आपने जो लिखा है वो एग्जीक्यूट होगा. बट ट्रस्ट के केस में तो आप उस प्रॉपर्टी का अगर आप प्रॉपर्टी को रेंट पे भी लगा रहे हैं तो उस रेंट का भी क्या होगा वो भी आप कंट्रोल कर सकते हैं. You can write that also, that this amount should be used for funding the education of my child. For example, it's possible during the lifetime, the will is not, and the trust is yes. Estate duty saver, no, and trust, yes. Wealth planning for minor beneficiary, will में आप to certain extent कर सकते हैं, but trust में completely आप कर सकते हैं. So trust, we advise for people who have very minor children and dependents who are not physically or mentally fit. Few tips to avoid litigation. Keep your will at a safe place. You can share it with family that you have made a will. Share the place of storage with executor only. Sign the will in presence of the witnesses. Attach doctor's certificate about your physical and mental fitness. Please remember that doctor certificate should be around the date of the signing of the will. ऐसा नहीं हो कि आप जून 23 में साइन कर रहे हैं और जनवरी 23 का एक डॉक्टर सर्टिफिकेट है. Then it's no use attaching that certificate. Mention that this will supersedes all the existing wills made on so and so date. Video recording is optional. You can read out your will and that can be video recorded. When you're signing, that can be video recorded. to keep it as a proof that this was the will which was signed, or this is what I said I intended to write in the will. How to write a will? Date of writing will is important. Personal details are important. All your personal details, your name, your father's or husband's name, your date of birth, your address, all these personal details, absolutely important. Declaration of sound mind and good health. Last will and revoke all existing will. Executor details, beneficiary details, asset details mentioning beneficiary against each asset, contingent beneficiary, non-beneficiary, special conditions. What is special condition? Special condition where, suppose you want to write something like, my son will get so and so, son will get my house property only if he does not marry this girl, name of the girl, because I don't like her. ऐसा भी हो सकता है आपकी will में, आप लिख सकती हैं, ठीक है? General declaration and protective clauses. This is the work of the lawyer. They will give some general declarations and protective clauses so that your will is well drafted. Witness and testator's signing is very, very important. Okay. So before this, I will get back to the Ankur example so that we can wrap this up fast. Okay. Ankur, where are you? Okay. Where are our questions? Our questions. How would the family manage their immediate needs? For this, the answer is always have joint accounts in banks with your spouse, or your if your spouse is already not there, then with your child maybe, but so that they can manage their financial needs. Right? If your child is a major, then you can have it with your child.
Or if the child is, ma'am, if the child is nominee, then he or she can manage the accounts?
No, they cannot manage. Nominee can only take care of what is already there in the bank account. अगर कुछ expenses के लिए चाहिए, तो they can ask for it. They may or may not be granted that, but they cannot operate it.
They cannot withdraw money from the bank.
It will be handed over to the nominee to take care. So वो उसको मिलेगा, वो withdraw भी कर सकता है, उसको use भी कर सकता है, पर जब succession law या will के हिसाब से जब division होगा, तो वो money को भी उसको account for करके division करना पड़ेगा. He has to give it back. It's not like that person can spend it.
Okay.
Who will manage the business? Do we remember? उसका एक son था, abroad था.
Yes.
India आना नहीं था, right? So who will manage the business? Very important for people who are having businesses, individual families, not joint families, जिनका business है. Even for joint families, succession has become inevitable, but business succession for individual businesses. Please talk to your husbands, your fathers, that please have successors in, and also in your own businesses, ladies. Wherever you see that मेरे पास एक successor नहीं है, you should have plans for succession of your business. क्या होता है? After the person dies, उस business की value एकदम से गिर जाती है. तो जब हमारी value अच्छी है, हम उसी time succession पे ध्यान देना, तो हमको कुछ return मिलता है. Who will take care of the father and sister? Like,
No, but in this case, who will manage the business, ma'am? In this case, the son is not willing to come.
yeah, this question I have put because I wanted to tell everyone that business succession is also very, very important. Ankur ke case mein, he did not have a business succession in place, and his son was also not ready to take care of the business. And one of the daughters had already left with someone she loved. Second daughter was into an insolvency case. So the entire scenario is this, that no one is there to take care of his business, right? तो बिजनेस सक्सेशन भी इंपॉर्टेंट होता है. जितना हम लोग सोचते नहीं है कि ठीक है हमारे जाने के बाद जो वैल्यू होगी वो तो मिल ही जाएगी, ऐसा नहीं होता है. हम लोग को बिजनेस सक्सेशन पे भी ध्यान देना होता है. प्रियांश, कैन वी टेक द क्वेश्चंस? मैं ये फिनिश कर लूं जल्दी से प्लीज. आई विल टेक अप द क्वेश्चंस, प्रॉमिस. या And who will take care of father and sister? Father and sister, both not legal heirs. Sister was a widow, you remember? Father dependent. No will. Class 1 heir to hai nahi ye dono. Right? Who knows what assets and liabilities he had and how to access that? Okay, what we have been talking through all the entire week. कि हम लोग को कैसे अपने डॉक्यूमेंट्स रखने चाहिए, क्या करना चाहिए, बिकॉज लाइक आई सेड उसकी वाइफ एजुकेटेड थी बट होम मेकर थी. डू यू रिमेंबर? वाइफ दो वेल एजुकेटेड बट चोज टू बी अ होम मेकर. इवन इफ शी इज अ होम मेकर शी शुड नो, राइट? तो सब कुछ एक जगह पर होना बहुत ही जरूरी है. How would one protect from misappropriating wealth accumulated for the benefit of the family? Misappropriation of wealth मैंने यहाँ क्यों लिखा है? क्योंकि none of the children were there to take care of everything, right? Secondly, father was not in a position, he was dependent, sister was a widow, and wife was always a homemaker. अब इस situation में क्या होता है? You have to rely on your staff or your managers, right? At this point, or now even more because everything is so electronically handled, that misappropriation of wealth is easy. It's not difficult, right? When the person who is in charge of everything is no more, there are people who take this situation to their advantage and misappropriate wealth. So we should give all this access to our spouse so that, misappropriation does not take place. They are in full charge of everything, right? How to protect second daughter share from getting it attached by the court? Succession law जब play करेगा तो उसकी daughter को भी मिलेगा, right? Daughter is a personal guarantor and her company is into insolvency. So obviously the court will attach that. तो अगर उसने will बनाई होती और उसमें लिख दिया होता कि if any of my children are personal guarantors to any company, their personal property cannot be attached, whatever they get from this inheritance, then it would have worked. How to protect the distribution of wealth to first daughter? He did not like his first daughter, but she being a legal heir will still get some share in his property, right? So this was why I had put in so many questions. After this session, I think the questions would have been clearer. So let's get started. So we come back to the first session. How to get started about this. Gather all the information that a family should know in one place. Back to square one, where it starts. Okay, what are the information types? I've just wrapped it up the entire week. I've just wrapped up the entire week in 3-4 slides. Sensitive financial information and general information all should be taken care of. This is the list of sensitive informations which I had asked you guys to start collecting. Details of vehicles, tax consultant, insurance agents, stockbrokers, mutual fund consultants, any other consultants, bank accounts, bank lockers, electronic money details, medical and life insurance, very, very important. Immovable properties, liquid investments, details of debtors and creditors, liabilities, nominations, guardian appointment for minor children, dependents, pets, POA, and will. Okay, all these should be thought of one after the other so that you are in a position to decide what to do about each of them. General information, family doctor, specialized doctor, doctor on call, ambulance services, urgent medicine, document details, details of important people, user IDs and passwords, booking process details and complete registrations, Wi-Fi details, details of all close contact of kids. How should we do it? Last week I had in detail told how should we be doing it in Excel sheet, password protect such accounts, upload on Google Drive, share with family, passwords, how should you make passwords, place of storage of all physical documents should be according to the importance and use, scan all documents and keep a copy. Last but not the least, talk to your family, take small steps and do a dry run. Practice it. अगर आपको अपने बच्चों को सिखाना है तो मैथ्स के सम की तरह इसको प्रैक्टिस कराइए। आप सोचते हैं आप बता देंगे और वो कर लेंगे, तो पहली बार ये करने में दिक्कत आती है, बिकॉज पीपल आर नॉट श्योर ये कैसे करें। बिकॉज अगर अगर बैंक अकाउंट से आपको 10 रुपये ट्रांसफर करने हैं ऑनलाइन, तो भी आपके बच्चे को प्रैक्टिकली आपको एक बार कराना होगा। अगर आप नहीं सिखाएंगे, वर्बली बताएंगे, तो गलती होने की चांसेस होती है। Dry run is important. What is a dry run? Where even if you're living, you behave as if you are not into the picture. They have to run the house for a day without you, without being able to contact you. And they should be given situation कि आज गैस भी बुक करना है, आज वॉशिंग मशीन भी ठीक करानी है, और आज एसी भी ठीक कराना है, और एडिशनली ये दवाई भी ऑर्डर करनी है आपको, एंड बैंक अकाउंट से ये पैसे ट्रांसफर करके हमारी इंश्योरेंस को रिन्यू कराना है। ठीक है, तो अगर हम लोग ये सब काम देते हैं एंड वी टेल देम टू डू दिस, दैट्स कॉल्ड अ ड्राई रन, मींस विदाउट यू बीइंग देयर इन द पिक्चर दे शुड बी एबल टू डू दिस। ठीक है, आई नो इट्स a big thing, it's so easy to say, even I'm practicing this with my kids. It is difficult because telling them that mummy is not available is also a big thing, but believe me, they become more responsible, they learn new things, and for women it's absolutely more important to learn whatever I've been trying to touch on in the workshop in the last week. Thank you so much. That's all I have to say. I'm open for questions now.
So we can have question answers round. Anyone who is into questions can please all shoot over.
You can read out the questions to me, Simi, so that I can start reading. Because if banks don't allow to add daughters in HUF. Banks don't allow daughters to add in HUF.
ऐसा तो नहीं है।
नहीं, क्या बोल रहे हैं आप? नहीं, ऐसा नहीं है. Please clarify from your bank. ऐसा नहीं है. I am in my office. Okay. Mother, daughter, son, how it's divided? Mother, daughter, and son, how it's divided equally? You're talking of a Hindu male?
Yeah.
Okay.
Hello. Hello.
Yes, Priyansh. Please tell me.
Yeah, hi. This is Deepika. It's my son's ID.
Okay.
Sorry about that.
I'm so
I
sorry.
just wanted to ask one small bit. Like in the Ankur example, we were
Hmm.
speaking that who takes over the family business.
Hmm.
So in like just because there is no will, so even the daughter one has full. Daughter one can also get the family business to run. The father didn't like her for what she did. Doesn't make her wrong otherwise. If father would have left the will, that's a separate case. Correct?
Absolutely. So these are two different things, Priyansh. In a will, you can bequeath your assets and your liability, and your assets. And
But
your
she's
liability.
rightfully, she can get the full, like, because there is no will, she gets the full, like, she will get the full, she will get equal share to the property, correct?
And she is
And in-
entitled to her share.
Namita, your
Okay.
voice is not audible.
And
Wait.
in HUF,
Hear
the
me now?
mother gets or not?
In an HUF, the mother gets.
So
The
the
son
shares are
also
only for
gets.
the children,
No. The mother also gets.
but the wife doesn't get.
The wife also gets the share. She is not the co-partner. She is the member. There is a difference between a co-partner and a member. Co-partnership comes only with birth, and membership comes with marriage. Okay, but only in case of females. Males are not the members in the HUF of their father-in-law, but females are members in the HUF of their husbands by marriage. Okay. Now, co-partners have the right to ask for partition in the HUF. वो बोल सकते हैं कि आप HUF को अब dissolve करना होगा, ठीक है? But members ऐसा नहीं कर सकते. तो अगर मिस्टर एक्स है और मिसेस एक्स है और उसके 3 बच्चे हैं, तो तीनों बच्चे irrespective of whether they are daughters or sons, they can ask for partition in the family, in the HUF, sorry. But the wife, Mrs. X, cannot ask for partition. But जब partition होगा, तो उसको भी share मिलेगा.
Okay, okay. So co-partners, matlab member will get the share, but the right to divide is only on the co-partners.
Right. Ask for partition.
Okay. That was totally not clear. So thank you so much on that. I think I'm
Actually,
good
I
with
did not
that.
elaborate on HUF because succession में already इतना कुछ रहता है कि
No,
मैं
I
ज़्यादा
understand. And
ध्यान
generally,
नहीं
because
देना चाहूँगी.
basic Hindu families or business families do have an HUF, where like the way they
It's a
run. So,
tradition. I think all of us have HUF.
yeah, so that's what. Okay, thank you.
Thank you so much. Okay, there's a question if father and have joint accounts. Not clear, Alka. Alka, I cannot understand your question. Can you please tell me what you want to ask?
Actually, the questions are what you were talking that time. The
Okay.
questions are half-heartedly based, like matlab, it's like based.
It's
अच्छा, उसी
related
समय
to
के लिए
that
था. हो
actually.
सकता है कुछ questions already answer हो गए हों.
I would request the member to ask again rather than reading it from the chat box because the questions are not clear in the chat box. We can, girls, we can raise our hands and ask if you have any queries, or you can read out your question.
Can I ask a question?
Yes, Pramila ji.
Pramila ji.
What are the rights of a mentally retarded child?
The rights of a mentally retarded child are as
Yeah.
good as a normal child.
Okay.
सारे rights जो एक normal child के होते हैं, वो एक mentally retarded child के होते हैं. All
Same
right.
होता है.
एकदम.
Okay. So
But
ये
our
तो-
responsibilities are more because for
Huh?
them, our responsibilities toward them are more because we should be more aware कि उनके लिए हम लोग को will या trust timely बनाना है. That is our responsibility. उनकी right का जब हम लोग बात करते हैं, तो they have equal right as normal
No,
children.
they have the equal right, then who looks after that?
That is why we need to make a trust for them. So we can
Okay.
appoint someone to look after them.
Supposing there is no trust made by the father and both father and mother are
Because
deceased.
आप कोई अगर देख लिया तो देख लिया. It becomes a very difficult situation.
आपकी आवाज नहीं आ रही नमिता.
Can you hear me now?
Yeah, but your voice
Yeah.
is little, not a little inaudible.
Happening.
It's cracking actually in between.
Now is it okay, Sami?
Yes.
Yes.
Okay. So see, if there is no will, no trust, then we have to really leave it on God कि कौन देखेगा क्या करेगा. There is no guarantee ना, क्योंकि एक mentally retarded बच्चे को raise करना या एक adult mentally retarded को देखना, it's not an easy task. It's not an easy task, and no one wants to take up that kind of responsibility.
Correct. Yes. Thank you.
Thanks.
Can I ask a question, Amita?
Yes, please.
So if the father has passed away and there are two daughters,
Right.
and one is made the, there is no will,
Hmm?
and one is the nominee of the shares and everything, but it should be divided equally between two, right?
Right. It should be.
It should be.
There are some cases wherein it is upheld that in case of shares companies, nominee will get the shares.
Oh,
Okay.
Okay.
There have been some case laws, but there is no law which has been made. So there is a difference. Act नहीं है इस बारे में, but अगर केस होता है तो कभी नॉमिनी जीत सकता है only in case of shares. Since
okay.
आपने शेयर बोला, इसलिए मैंने ये बात.
हाँ, shares का ही पूछ रही थी मैं.
हाँ. ये
Okay.
पॉसिबल है, बट अगर कोई केस नहीं हुआ है, अगर नॉर्मल प्रोसीड्योर से देखा जाए तो दोनों को इक्वली मिलना चाहिए.
Correct.
इफ
Okay.
देयर इज नो मदर,
Yeah,
अगर mother
yeah.
है, तो मदर को भी मिले.
Correct. Thank you so much.
You're welcome.
Namita, I would like to ask one thing. Usually in banks we fill the nomination form. मतलब जरूर से हम भरते हैं कि भाई अचानक से कुछ हो गया तो the nominee can take care of the bank. So in this question, when a person dies, so उसका immediate expenses को meet करने के लिए nominee क्यों नहीं उसका bank account use कर सकता है?
कर सकता है, मैंने क्या बोला था, यूज कर सकता है, बट सक्सेसर अगर कोई और हुआ या बेनिफिशियरी कोई और हुआ ना, तो उसको वो अमाउंट भी उस लौटाना पड़ेगा. आप समझ रहे
हाँ, वो बाद में जब डिविजन होगा तो उसको अकाउंट को.
Yes.
बट एक बार अगर इमीडिएट एक्सपेंसेस किसी को मीट करना है तो द नॉमिनी कैन यूज द बैंक अकाउंट.
फॉर्म फिल अप करके द नॉमिनी कैन स्टार्ट, बट एवरीथिंग हैज टू बी अकाउंटेड फॉर कि क्या पैसा विथड्रॉ हुआ है, वो कहाँ यूज हुआ है, किस पर्पस के लिए यूज हुआ है, बिकॉज एवरीथिंग कैन बी आस्क्ड.
And if we have like we are in the age group where our childs are not majors, they are still
Right.
minors. So
Absolutely.
if I hold a bank account or if I hold a locker and they ask me who is your nominee, so I don't want to make my child because he's a minor. So should I make my child or should not? Because
लॉकर आई वुड नॉट सजेस्ट कि आप अपने बच्चे को नॉमिनी बनाएं, बिकॉज लॉकर ऑपरेशन है या बैंक अकाउंट से पैसे निकालने, दोनों ही तो आपके बच्चे को अलाउ नहीं होगा जब तक वो मेजर नहीं हो जाता.
exactly.
उसका गार्जियन ही करेगा. अगर आप माइनर बना भी देते हैं तो योर लिविंग स्पाउस who should also be the natural guardian of your child will be the person who will be operating on their behalf.
Okay. Even if he's not a nominee of the account.
Yes, because he's a natural guardian. Unless and until you have made a guardianship document wherein you have declared कि मुझे मेरे spouse पे बिल्कुल भरोसा नहीं है, तो आप ये सब कुछ मेरे बच्चे के guardian Mr. or Mrs. so and so करेंगे. So in that case, the guardianship changes and then it can be done. But again, अगर natural guardian जिंदा है, तो ये guardianship जो हम लोग बनाते हैं document, it also can be challenged.
Okay.
Natural guardian is always given preference agar the natural guardian is not harming the child.
No, my question was a little different. My question was कि should we make minors or we should not make?
Again, you can make, because अगर आपको आपके spouse पे भरोसा है आप बना सकते, because वो natural guardian है, right? But अगर आपको अपने spouse पे भरोसा नहीं है तो आपको नहीं बनाना.
Okay.
That is what I meant.
Okay, thank you.
So Namita,
I have a
when we are making a will and the person who has made the will dies, and then you need to file a probate. So then there are expenses in this also, and from what I know, there are major expenses.
Yes.
But I mean, you have to bear, whoever is the beneficiary of the will, they will have to bear those expenses.
No, it's the expenses are borne by the estate of the testator.
Namita, your voice is not audible.
The expenses are borne by the estate of the testator. मतलब जिसकी डेथ हुई है उसके पास जो पैसे थे उसमें से यूजुअली एक्सपेंस होता है, unless and until the legal has decided कि नहीं ये एक्सपेंस हम लोग कर लेते हैं, कोई प्रॉब्लम नहीं है.
Okay. And it is a long drawn process?
See, probate takes at least 4 to 9 months. If it is not a challenged one.
Okay.
अगर केस शुरू हो जाता है तब तो शायद आपके
then it takes a long
तो
time.
आपको नहीं मिलेगा.
But even if it's not challenged, it takes at least 4 to 9 months to get all things in order.
आजकल 4 to 9 months में हो जाता है, प्रॉब्लम नहीं होगा.
Okay. Thank you, Namita.
Thank you.
I have a question, Namita. Achha, their section has got it.
Please tell me.
Namita,
Yes.
I have a question.
Yes, Rinku ji, tell me. बोलिए.
Yes. मेरा क्वेश्चन है कि सपोज हस्बैंड का बिजनेस है, पार्टनरशिप बिजनेस, और अगर बेटा भी उन्हीं पापा का बिजनेस संभालने लग जाए तो लाइक फिर लेटर वो कैसे फिर लाइक बिजनेस अगर कुछ मिसहैप हो जाएगा कुछ तो कैसे फिर डिवाइड होगा या क्या करना चाहिए लाइक यू गेव आपने बोला ना कि लाइक उसका भी एक तो वो होना चाहिए कि किसको जाएगा और क्या सब चीज जाएगा सक्सेशन तो
So, business succession is again a very wide, topic. But just to throw light on the particular question that you have told, partnership के केस में पार्टनरशिप डीड जो होती है वो सबसे इंपॉर्टेंट होती है, भले ही वो आपका बेटा ही पार्टनर क्यों ना हो, बट देयर इज अ पार्टनरशिप डीड. So that is the most important factor which decides how things will be done.
the spouse को फिर like suppose as a wife then how will it like divided her prop जो भी
Yes.
earnings है
So in a partnership, suppose करिए 50% to the husband and 50% to the son था, ठीक है. तो अब फादर का जो 50% था, अगर फादर की डिमाइस होती है सपोज, तो फादर का जो 50% था उसमें फादर के जो लीगल हेयर्स है उनको मिलेगा. अगर विल नहीं है तो फादर के लीगल हेयर्स को मिलेगा, और अगर विल है तो विल के हिसाब से जाएगा.
अच्छा और वाइफ को भी लाइक 50% मतलब
नहीं,
फर्स्ट इनहेरिट कौन होगा वाइफ की चाइल्ड
both.
बोथ
Both.
ओके
So eventually the child gets another 25% if there's only one child and the spouse.
अच्छा ओके थैंक यू
Thank you.
So do we have any more questions?
I want to say,
Yes, Preeti.
yeah. Thank you, Namita. Very nice session. A lot of learning in this.
Thank
Thank
you
you
so
so
much.
much. There is a question which I have put in the chat box.
Yes, it's a long question. You want me to read it out for the entire group?
Yes, please do.
Suppose a widow of a Hindu joint family business having a daughter gets married. Widow of a Hindu joint family business.
Remarry.
Yeah, okay. Now the widow of a Hindu joint family business एक अलग चीज हो जाती है और HUF अलग चीज हो जाती है. आप क्या मीन कर रही हैं यहाँ पे? HUF is an entity, मतलब उसको तो आपको बनाना होता है, राइट? और हिंदू ज्वाइंट फैमिली बिजनेस जो एक बिजनेस में कोई था और उसके बाद उसकी शादी हो जाती है, वो तो अपना पर्सनल कैसे बिजनेस रन कर रहा था उस पे डिपेंड करता है.
Joint business में.
Yeah, but do you really mean a HUF here?
No. It's a joint business and it was a sudden death. So there was no will regarding it and no succession.
Right. And there was a
Because of the
remarriage.
young age. Yeah, because of the young.
Right. And she has an unsuccessful remarriage. She returns to the previous in-laws house. What is her right in the family and her daughter from the first husband? See, as the wife in the first marriage, okay, what happens is that उसको अपने husband से जो inherit करना था वो तो उसको मिलेगा ही.
Remarriage के बाद भी.
पर उस remarriage तो बाद में हुई है ना, वो तो फिर भी अपने हस्बैंड की विडो थी ना, उसको मिलेगा, ठीक है. तो दैट राइट शी हैज. ओके, वंस शी मैरीज समवन एल्स, so she is now the wife of someone else, right? If after that she is divorced, तब तो ठीक है. Now she remains the daughter of so and so, and she is not the wife of anybody. आप समझ रही हैं? सेकेंड मैरिज के बाद तो फर्स्ट मैरिज का तो कुछ है ही नहीं अब, तो वो उस फैमिली की डॉटर इन लॉ भी नहीं है. हम लोग सोशली इस चीज को मान सकते हैं बट एज इन नहीं है, ठीक है. सेकेंड मैरिज भी अगर नहीं टिकता और डाइवोर्स हो जाता है, नाउ शी इज नॉट मैरिड, शी इज अ डाइवोर्सी.
Yes.
पर अगर इसके बच्चे होते, इफ शी हैड किड्स, life long the child is the legal heir of the father's property.
First husband.
Yeah, of the first.
The child has the rights, but the widow doesn't have it. Or
Widow has it. Widow has it. Widow को जो मिलना था वो तो मिलना ही है.
But she remarried, so she doesn't have.
वो तो पहले ही मिल गया ना. अब मतलब
अगर if she remarries तो first marriage stands null and void ना, तो वो तो फिर question ही खत्म हो गया. अगर पहले मिल जाता है उसके बाद वो शादी करती है तो वापस वो in-laws के घर भले ही आ जाए.
उसको
अब
कोई
कुछ
राइट
नहीं
नहीं मिला है
मिलेगा.
फर्स्ट मैरिज से, बिकॉज वो इन-लॉज ही उसका शादी करवा दिए वापस, बट ड्यू टू सम रीजन शी टुक अ डिवोर्स. सो
अगर
वहां से
नहीं भी मिला था तो भी as the wife of the first husband is entitled to a share. वो तो मिलेगा ही उसको. जो उसके हस्बैंड की डेथ तक उसके हस्बैंड का प्रॉपर्टी था, उसमें जो शेयर उसको मिलना था वो मिलना चाहिए.
in spite of the divorce, second divorce, मतलब second marriage divorce.
क्योंकि at the point जब ये सक्सेशन होना चाहिए था तब तो वो विडो ही थी ना उसकी.
हाँ हाँ.
Right.
Excuse me. To this, I have a point to raise.
Yes.
I'm sorry to cut there, but if the HUF is in father-in-law's name, so
We are
that
not
HUF
about
is,
HUF.
sorry?
We are not talking of any HUF here.
No. I know we are not talking, but I'm
Okay,
saying,
not-
you said na, ki the
that's the
father, the
question.
husband's everything goes to the wife as soon as he passes away. So the husband, the daughter-in-law is in class 1 when it's comes. So now she's not the daughter-in-law or the wife of the deceased son. She's got married into another family. So then that HUF she's not a part because the HUF is on till the father-in-law is there, because he is the one who's made that HUF.
There was no query about any father-in-law's expenses. So what you were trying to say is there is an HUF of the father-in-law जिसके बारे में बात हो रही है, right? You
Yes.
want to add one more thing to this, right?
Yeah.
Father-in-law is also not there then.
Then तो HUF is not there, वो तो उस time ही फिर distribute हो गया. But if father-in-law is there, I'm asking in that case. I'm making the Hindi movie more complicated.
It's, I cannot hear you.
Father-in-law is there and she's already left the family. She's no more the widow of the son. तब कुछ नहीं
But
मिलेगा.
the son was entitled when he would have been there, he would have been entitled.
Yes, he would have been entitled. अगर इसके बच्चे होते तो मिलता, because she no more has she does not have any kids and she is remarried. तो
Okay,
नहीं
got
मिलेगा.
it.
Yeah.
Got it. And Namita, one small request. This was such a wonderful, wonderful session. I would just request, in case if it goes with you, can you share the PDF that you were showing us so that it's easier to, move on?
But out of my experience, nobody ever sees the PDF. But I will share the PDF. I do not have an issue in sharing the PDF.
No, it was really so well explained in it that, you were explaining with every line, but when you read the line, I'm sure the entire explanation falls in right in place in our mind itself.
Thank you so much. I will share the PDF.
Thank you so much.
Namita ji, means the end result is that she is holding the title or the name of the parents' house, not the first-in-law. Is it? We cannot get
नहीं सकती.
loud, please.
She cannot keep the surname of the first. वो नहीं रख सकती है.
And the paper of the divorce went in the name of the first side. जैसे जो surname है, it went for the divorce from the first in-law side, because they only made the marriage and they only divorced it, and she was welcome in the first house. Then where does she stand? Your loud voice, ma'am. Your voice is not clear.
Thing, then we have to go into more details. देखिए, अगर ये केस इतना complicated है ना, तो कुछ paperwork देखना होगा, तभी मैं और कुछ बता पाऊंगी. First क्या हो रहा है ना कि I think there are certain things which we have to look into to decide which way she falls. Right?
Because half the family is accepting her, half the family is not accepting her, since it's a joint business.
I get it.
So I think there are a lot of paperwork involved. I think Preeti can connect with her personally.
टाइपिंग कोई बेटर होगा, समय हम लोग ना ले तो अच्छा रहेगा.
Because speaking verbally like this won't help it out. You need to look into the matter very deeply. So if it's a very genuine case, just connect with her personally. Or if it's a made up, then so ठीक है, इन्होंने
not made
answer
up,
कर
it's a
दिया.
genuine case.
No, I'm saying जैसे मेरा question made up था, hypothetical question था. Your question seems very genuine, Preeti. आप connect कर सकते हो उनसे. Because मेरे को भी लगा the way you're speaking, it is very, it's like a case जो अभी चल रहा है, something like that. So you can connect with her personally. Anyways, Namita, it was a wonderful session.
Thank you so
Thank you
much.
so much. It was a very enlightening session. Now I would like my co-leader, Pallavi Bajaj, to close the session.
Thank you so much.
Your voice is not audible, Pallavi. Pallavi, you are muted.
Is it audible now?
Yes.
Hello everyone, I'm Pallavi Bajaj, co-leader Group 1G. I would like to thank each and everyone who have joined the session today. And first and foremost, I would like to thank Namita for such a powerful and informative session. I'm sure we all will be executing her valuable advices and getting some benefits out of it. And I would like to thank our Cafe Mentor founder, Kavita Agarwal, for always being so supportive of our all initiatives. And most importantly, want to thank all my wonderful audience, my cafe members, for taking out time for this session. Thank you, everyone. Thank you so much.
Thank you, everyone. We leaving the group. Thank you, Namita. Thank you so much.
Thank you, Namita.
Thank you so much for joining.
Thank you, Namita ji. Very nice session. Lots of learning.
Yes.
Thank you, Namita. Very, very
And
nice
Namita, please
session.
share both the sessions PDF files.
Yes.
Thank
We'll
you.
go through it,
Last session
and
also.
yeah, we would like to have more such sessions because very enlightening for us.